Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the program where we cover the most interesting live trials and legal stories in the country today. And we have a busy day, so let's get started right now. First up, let's talk about our first live trial. We expect to be live this morning in the Jeremiah Monell case out of New Jersey. You might remember that this man is charged with the murder of his wife, Tara O'Shea Watson, by allegedly stabbing her to death multiple times in her home. Prosecutors say that he stabbed her at least 48 times. And one of the most disturbing aspects of this entire case, the couple's 12-year-old son actually discovered the body. Even more interestingly, this man was apprehended after a 2-week manhunt. There is a lot going on in this trial. It was live last week. We saw opening statements. We saw a couple of witnesses, and we're going to be back live in that courtroom today. That's the Jeremiah Monell case. I do want to let you know that we're also going to be covering a little bit later on in the program our live feed out of California. This is the McStay family murder case, or the Charles Merritt case. Now, Merritt is charged, he's pled not guilty to the murder of his former business associate, Joseph McStay, who was 40 years old, his wife, Summer, who was 43 years old, and their 2 children, Gianni, who was 4 years old, and Joseph Jr., who was 3 years old. Their bodies were discovered in 2 shallow graves in the Mojave Desert. Yesterday, we saw the opening statement by the prosecution and the beginning of the defense's opening statement. We expect to be back live there again at 12 p.m. Eastern Standard Time. We believe the opening statements will continue. Really exciting but tragic case that we're following here on Law and Crime. Now, I also want to let you know that yesterday was an exciting day. We had a lot going on, including an update out of Michigan, Kalamazoo, Michigan, the Jason Dalton case. You know, that Uber driver that allegedly went on a shooting rampage, killing 6 individuals, was charged with multiple counts of murder, attempted murder, and firearms charges. Well, we have an update in that case in case you didn't follow our network yesterday, and shame on you for not doing so. So we're going to let you know about that in a minute, but before we do, there's always so much else happening in the country. Here's a special report about what else is trending in the news today. Take a look.
But that's my understanding, Judge, of what's been offered.
Okay. Prosecution has offered that, and it would appear that I would ask that he be sworn.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. For the record, your full name is Jason Dalton.
Correct.
Mr. Dalton, court has been advised of your intent to enter guilty pleas as to the various counts of this information. You should be advised that if you do enter such a plea, you will be waiving or giving up certain legal rights. You understand that?
Yes.
I'm looking for the advice of rights.
Okay, before we show you him actually pleading guilty, let's try to make sense of what happened. So joining me via Skype is our very own host here on Law and Crime, Bob Bianchi. Bob, great to see you.
Hey, Jesse, good morning.
Now, Bob, I got to ask you, this seemed to be a surprise. His defense attorney said this wasn't his plan, and at one point you're going to hear the defendant say, I've wanted this for quite a while. What happened here?
It's really peculiar because, you know, when you're doing the cost-benefit analysis as a defense lawyer, you might as well go to trial and put your defenses on and have a jury make the call. He just gave it to them. He handed over everything as if he got convicted of everything. And like you said, Jesse, he had a viable insanity defense. But I have represented criminal defendants in the past that have done things against my advice where I could have even done better for them in a plea offer, and they refused to allow me to do it. And you do what this lawyer did. It's against my advice. He's pleading guilty to everything. He's splaying himself out before the court without any of his defenses. And this guy, I guess, didn't want to put the family through that, which is, of course, a laudable thing.
Yeah, seems strange that he took other people's considerations into account, considering he's about to plead guilty to killing 6 people. Let's play, if we can, when he actually pled guilty, and it was pretty remarkable to see. Take a look. This was from yesterday.
Again, on that same date in Kalamazoo County, did you carry or have in your possession a firearm, to wit, a pistol, at the time you committed the offense of open murder with regard to Mary Jo Nye? That's a felony punishable by 2 years in prison, consecutive to any sentence that might be imposed for the murder of Mary Jo Nye. As to that charge, how do you plead?
Guilty.
Count 5, again, on that same date in Kalamazoo County, did you, in fact, commit a murder of one Barbara Hawthorne, contrary to Michigan law, a felony punishable by up to life in prison? Punishable by life in prison. As to that charge, how do you plead?
Guilty.
As to count 6, did you, again, at that date in Kalamazoo County, carry or have in your possession a firearm, to wit, a pistol, when you committed or attempted to commit the felony crime of open murder with regard to Barbara Hawthorne? That's a felony punishable by 2 years in prison consecutive to any other preceding term of imprisonment. As to that count, how do you count?
Guilty.
Count 7.
All right, that was Jason Dalton pleading guilty to all of those charges, and it should be noted that he faces a mandatory life sentence without the possibility of parole for each count of first-degree murder. Bob, do you think that he felt that his defense of the Uber app taking control over his body just wasn't going to fly, and maybe it would have, like he said, he didn't want to put his family through listening to that?
You know, it's hard to say, Jesse. I mean, there were a lot of facts, and I think the audience should know there's a difference between competency and not guilty by reason of insanity. Not guilty by reason of insanity is about what happened at the time of these murders, and there was a lot of evidence there. It's almost like typical classical insanity defense that the devil's telling him to do it and all this crazy erratic behavior. And my point as a defense lawyer to him would be, look, go to trial, present it. All I got to do is get one juror to say, you know what, I can't find guilty, and we hang the jury, and then I can plea bargain with the government for a lesser offense. But, you know, why just hand it over to them? And again, it's confounding, but it could be that he's reconciling, he did a horrible thing, and I just don't want to put the victim's family through it, and that's the basis upon which he gave up that viable defense.
Or, between you and me and our viewers on Law and Crime, maybe he's really not all there, and despite what his legal counsel is telling him, he just wanted to end this and didn't really, just wanted to take care of it, and that's it.
You know, Jesse, that's a really good point, and I'm interpreting here, but when he was being asked by the prosecutor, did you do this premeditated or intentionally, I forget the word, he had like this smirk. And
you saw that, right?
Yeah, and it's almost like he's in my mind, and again, I'm interpreting speculatively, like, not really, but I'll just say yes to get the plea through.
Hey, listen, there's really no love lost. This guy murdered 6 people, went on a shooting rampage, but we're just trying to analyze it from a legal perspective and see what ultimately happened here. I'll tell you what, though, we are going to take a break. We have a lot more that we're covering here on Law and Crime, so you know what I'm going to say? Stay tuned. We'll be right back. Okay, so this is the beginning part of the Jeremiah Monell case for today. Bob, as we listen to this trial, the graphic nature of this crime cannot be understated. I mean, there was a photo shown of O'Shea Watson to this jury. We see the evidence of all the blood. What does this do for a jury looking at all of these details?
Well, you know, the prosecution is allowed to introduce that information because it's relevant to the cause and manner of death. That's the legal reason it's admissible. But let's not make a mistake about this. It has an extraordinary visceral impact in favor of the prosecution. There's not a jury that's going to be looking at this horrible scene and not be impacted by it, which is bad for the defendant in the case. So while it's legally admissible and the judge will say at the end of the trial, don't be persuaded by passion, prejudice, sympathy, or bias, the fact is that's exactly what it creates. Yeah,
that's a good point. Okay, we have to take a quick break, but when we come back, we'll get a further glimpse into the crime scene. We'll be right back. Okay, so the first witness of the day is currently on the stand in the Jeremiah Monell case. Back here with Bob Bianchi. Bob, we heard the defense opening statement from last week. I'm just not sure what the defense really is. It basically said that they told the jury to keep an open mind. Is that what you got?
Yeah, pretty much. It's one of those defenses where you're there and you're like, I really don't know what I'm going to say. So keep an open mind and hope that on cross-examination you can start dinging them. But, this is going to be very, very difficult because in my experience as a prosecutor who has a child that witnesses a parent get murdered, that's a pretty compelling witness.
Yeah, you're talking, of course, about the son, the 12-year-old boy who found the body of his mother and then went to the neighbor's house and said that his mom got killed by his father. I mean, that is a witness. You can't strike at the credibility of that witness. What he said is what he said.
Yeah, absolutely. They're damning witnesses. There's no other way around it. There's no motive for them to lie. They're young. It's very difficult. I only go back to an example that I had in a murder case that I tried as a prosecutor where the defense lawyer's tactic was to really go after the young girl and cross-examine her brutally, may I add, to the point where the jurors were crying over what the girl was going through. And I thought that in my mind cinched a capital murder conviction as it did in that case.
Yeah, and just to note, these are the photos of those bloody knives that were found. Pretty graphic, being displayed to that jury right now. And as Bob and I just said, the defense attorney said, as each person comes, I just want you to listen to what they say, analyze it. Are they giving you answers? That's the defense. Let's take a quick break. When we come back, we'll be live in the courtroom. Okay, we got to talk about the evidence that was just presented to the jury that was collected from the crime scene. Bob, did you see that knife? It was bent. It was bent. It had blood over it, and it was bent. I mean, my gosh, does that just give you a level into what kind of crime was committed and what kind of killing was occurred here with this knife?
Yeah, no, Jesse, you had asked before, like, what a defense could be, and maybe I missed it, and certainly the trial will ferret this out. But usually in a brutal stabbing like this, where you see the bent knife, which obviously is another visceral piece of evidence for the jury, most times defendants, when there are people that are committing these crimes, will wind up getting incised wounds on their own hands during the stabbing as the knife is slipping, and there's such force is being used here, you would expect that. So I want to know if his DNA is on there, blood DNA is on there, whether or not when he was arrested he had cuts or any kind of marks or injuries that would typically be used or seen in a case like this.
No, and we have less than a minute, but you remember his bloody palm print was found on one of the knives, and that became an issue of contention between the prosecution and the defense.
Yeah, I mean, well, listen, that's a good piece of evidence for the prosecution, but that doesn't necessarily mean he's the person who did it. It could mean that he picked up the knife after, the crime was committed maybe by somebody else. I don't know. That could be the argument. But if his blood and his DNA is on that knife, or if he had injuries to his own hands, there's no way getting out of this. I just don't know that answer yet.
Hey, listen, it's incredible as more details keep coming forward about this brutal killing, and what a tragic case it really is. We have to take a break on our end, but Bob and I are going to be back to analyze a little bit more of this case as we cover it in real time. And you're just seeing all the evidence that was collected, and it was quite the brutal crime scene. So let's take a quick break. We'll be right back. Stay tuned here on Law&Crime. Welcome back to Law&Crime, everybody. I'm Jesse Weber, and thanks for joining us on an exciting day. We're live in one of our main trials out of New Jersey. This is the Jeremiah Monell case, where he is charged with the murder of his wife, Tara O'Shea Watson, by allegedly stabbing her to death. Now, I should note this case is live right now. We're in this courtroom, and okay, well, I'm just getting a report that there's a sidebar going on right now, so I can bring in my guest, another fellow host here on the Law&Crime Network, Bob Bianchi. I want to bring him back in as we talk about this. What an interesting day, the collection of evidence. And we were talking about it before. These knives are being shown to the jury, and my gosh, that larger knife was really bent. Bob, what do you think the jury is making of all of this evidence being presented? There's a lot of blood. They see these murder weapons. I mean, what do you think they're making of it?
They're very moved by it. Again, I mean, the brutality of the wounds on the victim herself are bad enough for the defense in this case. But when you see an actual knife that's bent due to the obvious force that was being used as the knife was being plunged into her body repeatedly, is a very powerful impact of a vicious, hateful crime. Jesse, as we're going through this, I'm just trying to figure out the defenses here. I'm wondering whether one of the defenses may be that the very viciousness itself and the brutality of it is a passion provocation case, that there was some sort of argument. And under New Jersey law, and I know New Jersey law pretty well, and these prosecutors are doing a great job, but if you can show 4 elements of passion provocation, it reduces a murder case down to a manslaughter conviction with a significantly reduced sentence. And I'm beginning to think this could be where they may go.
Now, look, you talk about brutality. Look at that bent knife. I have a question for you. He had the option for a plea deal that would have offered him 30 years in state prison. He rejected that. Now he could face life in prison without the possibility of parole if convicted. Why did he reject that?
Well, 30 years is a long time, and so, that's the offer that I would give as a prosecutor. I have done that myself, and if the defendant refuses to do it, then I always said to my staff, go to trial. I don't care if you lose the case. I'm not going to give the case away. But again, I think one of the reasons may be, Jesse, I'm starting to think more and more that they may say after the presentation of the evidence in this case that this is a passion provocation, and the difference there is 30 years was the plea offer, but on a passion provocation, the maximum is 10 years. That's a 20-year difference.
That's an interesting point. Yeah, maybe that's what the plan is. We're still at the beginning parts of this case. The prosecution is still putting on their evidence. We're going to go back live into this courtroom right now. Detective Michael Hughes from the New Jersey State Police is still on the stand. Let's go live. Okay, so, Bob, as we enter into a sidebar, let's just talk about what the motive here is. We've seen domestic violence kind of cases before, and I can't help but think about the James Colley case, too, how similar it is, where we believe that Tara O'Shea Watson took out these restraining orders and protective orders against the defendant before the killing. If he did do this, what kind of pattern is this where you see violence between spouses and soon-to-be exes because they were in the process of a divorce, where this just happens?
Well, I always used to say to my staff, especially the family unit that would handle domestic violence cases, that today's domestic violence is tomorrow's homicide. And that was probably about 60 to 70% of the homicides that I handled were emanating out of a domestic violence scenario. It is an epidemic in this country, and despite all of our efforts to do the best we can, I'm not going to lie to you, when we used to have a domestic violence-related homicide, I would run down to the family unit and say, well, obviously get the files out. Did we drop the ball somewhere here and not offer this victim the protection we should have? And thank God, in all the cases that I handled when I was the chief prosecutor, that never occurred. But, the DV paperwork is merely a piece of paper, and if somebody's intent on harming somebody, you've got to take other measures than the domestic violence protections to try to protect yourself. Who can figure? It's an epidemic, Jesse.
Well, what kind of protections could you take? Because a piece of paper, right? A protective order. If they're willing to kill someone, they're willing to violate the order. I'm getting word right now, Bob. We'll talk about that in a second. We're going to jump back live into the courtroom right now, but we'll talk about it on the next side. Okay, so let's just talk about something for a second, as I think they're in another sidebar. Bob, we were just talking about a protective order. Can only do so much, because if somebody's willing to kill somebody, you think a piece of paper is going to stop them. What do you do? Really, how do you prevent this from happening? If you have two people, maybe in the middle of divorce, maybe they're having a terrible domestic violence spat, what do you do to protect one party over the other?
You try to stay away from the potential perpetrator. There are safe houses for women. I'm saying women, typically women. I don't really know of any for men, but not that they're not subject to domestic violence. There are staying with other people. There is making sure some people get weapons so that they can protect themselves in their home, and alarm systems. And, you feel so bad for these people because they're frightened, they're afraid, they have to do all of these procedures, they're worried about their kids' well-being at the same time. It's rough, Jesse, but, seek the services of professionals in your jurisdiction to ask them what beyond the restraining order can you do to protect you and your children from the perpetrator is the best advice I could give.
Look, we're all trying to figure out what exactly happened in this situation, and His behavior, the defendant's behavior, Jeremiah Monell, throughout this trial has been a bit weird. Have you noticed that? I mean, at one point he didn't feel well. He showed up late. He's been complaining about maltreatment in the jail. What do you make of all this?
Yeah, you know, it's hard to say. I mean, it's obviously a very stressful situation. And then again, his lawyers are probably explaining to him what he should and shouldn't be doing inside of that courtroom, you know, and how to behave. You know, I don't know, not feeling well and feeling that they're maltreated in a jail is not something that's atypical in cases where people are on trial.
Look, I know it's impossible to try to figure out what's going on in his mind, but we're watching him as the evidence is being presented, and you don't see much reaction. I mean, we just saw bloody knives being brought out, and they're bent. One of them, look how big that knife is. I think this is one where you're going to see how big that knife is, and it's just bent. So the question is there anything we can glean from just watching him?
Well, you know, the jury's watching him, that's for sure. I can tell you that literally when compelling pieces of evidence come out, you literally see the jurors, you know, attention move to the defendant. The problem is I've seen defendants that have been emotive and reactionary, and juries have taken that the bad way. I've seen defendants have gotten angry, and juries have looked at that a certain way. And I've seen the ones like this guy who's stoic, and they look at it like, you know, look at this guy. He doesn't have any kind of reaction. It's really hard, and as a defense lawyer, you're trying to explain to your client how to appear, but you also don't want them to come off looking unnatural. So it's very difficult to interpret what a jury is going to interpret when they're looking at a defendant.
What do you advise clients who are going through these kinds of trials? Do you say, hey, listen, you know, take a bunch of notes, talk to me, make it look like you're informed? I mean, what do you advise them?
I advise them pretty much to stay out of my face, you know, while I'm doing my job until I'm like turning to them, and I will strategically move towards them to talk to them, to animate them. If I feel I'm watching everything going on in the courtroom, and if I feel he's looking too antiseptic or she's looking too antiseptic, then I'm going to engage them a little bit. And if I feel like they're getting too emotional or whatever, then I'm putting my hand on the table to calm them down. I'm actually guiding the emotional reaction of my client through my body language and things that I'm doing, so that he's not just sitting there like a potted plant like this guy is. I would definitely be engaging him, talking to him, making sure that the jury sees that this is a real human being.
Hey, maybe one day we'll cover the Bob Bianchi trial. Our very own network host is one of the stars, and we could watch you in action, but we'll see. We'll cover that at a different time. I'll tell you what, Bob, I want you to stand by. We're going to take a break. They're currently still in a sidebar. It's a great time to take a commercial break. When we come back, we might be live, or we'll have a lot more to talk about. Stay tuned. Okay, so Bob, you mentioned something interesting before. We were trying to figure out what the defense strategy is, and really it might be premature to say that because we're still seeing what the prosecution is doing. Do you think a part of them, because they had such a vague opening statement, they're just waiting to see what the prosecution presents, and they may change their defense tactic later on? They may call witnesses they didn't think of until they want to hear what the prosecution's case is, or is that not a possibility?
No, I think so, Jesse. The more I'm watching the evidence coming in, the compelling nature of the evidence, the viciousness of the evidence, I am far more convinced now than I was yesterday that the defense tactic is to kind of lay low to see if they make any mistakes in the presentation of their case, but very well may go to the client at the end of the state's case and say, hey, listen, dude, we got to argue passion provocation here so that we can get this reduced from murder to manslaughter with a max 10-year sentence. The stabbing, the bloody clothes that you see there right now, the nature of the viciousness of it speaks of out-of-control, outraged, and enraged behavior. Now they would have to meet the definition of passion provocation, which is that there was a justifiable provocation, that a reasonable person would be provoked, that in fact they were provoked, and that they didn't have an opportunity to cool off, quote unquote, prior to the actual commission of the murder. That still may be a tall order for the defense.
Yeah, I'll tell you what, Bob, let's talk about that on the next break, after the next break, because the facts might not support it. Let's take a quick break, and we'll see. Welcome back to Law and Crime, everybody. We're covering the Jeremiah Monell case. We're live in that courtroom in New Jersey. There's a sidebar going on right now, so it gives us some time to analyze this case in further detail. Back here with Bob Bianchi. Bob, you had mentioned before our last break the idea of passion provocation. Yes, he's charged with murder. What will the defense maybe argue? And perhaps they'll argue that this was a sudden heat, fit of rage, and took the knife and stabbed her. The interesting part about that, though, is if you read the prosecution's claim, they say he beat and choked her, then went to get the knives and ultimately stabbed her. That moment of attacking her and then stabbing her, could you still argue passion provocation? Because the other way of looking at it is he had a time to reflect, and before he could have stepped away and he didn't have to kill her.
Right. I mean, it comes down to, under the law of New Jersey, whether a reasonable person would have cooled off during that time. Jesse, I tried a case exactly like this one time. It wasn't a domestic case, but the fight started. The person left and went and got the knives, went back into the location and stabbed and murdered and killed the guy. And that was exactly my argument as the prosecutor to combat the passion provocation defense, is that when he left, he made a conscious decision to leave. He had an opportunity to deliberate. He had an opportunity to cool off. But instead, he went to get the knife to do the very thing he couldn't do physically, that is, to kill him. So that certainly will be an argument that the prosecution will say, that they cooled off. And they will also say that it wasn't a reasonable provocation, whatever that provocation may be. So even though the defense is available, and it may be the only defense he's got, it doesn't necessarily mean, obviously, that it will prevail.
Okay, you mentioned an interesting word, fight, and you said provocation. Would the defense need to put some evidence in that there was a fight, that maybe she attacked first? But then again, even if they can show that, wasn't there a restraining order where he wasn't even supposed to be near her?
Yeah, I mean, and then that'll come out too, but the restraining order isn't going to vitiate or eliminate a passion provocation defense. It's a violation of the restraining order, which he is charged with in this case, which is a fourth-degree crime. It's a minor crime. So, you know, they're going to basically say, forget the restraining order piece. The point is what happened at that point in time. Was there a provocation? Was that provocation reasonable? Did he, in fact, respond? Was he, in fact, provoked? And did he have an opportunity to cool off before he committed this murder? Those are the factors that the jury will determine. And the only reason I say it's in the case is because of the viciousness of the crime itself.
You know, that we believe that friends of this young woman will say that she was suffering for years at the hands of the defendant, that he beat her, she tried to escape from him. That's why she got these, these orders taken out against him. Does he need to put in witnesses, put in evidence that perhaps there's two sides to this story?
That's a great question, Jesse. Well, yes, they have to put evidence in because it's an affirmative defense that the defense has to prove. Now, I don't know whether he gave a statement or he didn't give a statement. Sometimes by the introduction of the prosecution of a statement, it can come in there and then the defendant doesn't have to take the stand. But typically speaking, a defendant will take the stand in order to try to convince the jury that the passion provocation defense is appropriate. Now, what I love about your question is, if you're really wonky and nerdy about the law, is evidence rule 404, other act evidence, is allowed to be used by the prosecution where typically is not. The bad character stuff you're talking about, the friends talking about the previous domestic violence and all the horrible things he did in his past, because it's not a trial by character assassination. However, if it goes to an element of the crime like motive, opportunity, plan, preparation, then you can introduce it, not to say he's a bad guy for those things, but to say that evidence shows that this isn't passion provocation. This was his motive, his purpose, his intent, his plan, his preparation to actually go and kill her, not because he was enraged.
You know, Bob, I just want to let our viewers know there's currently still a sidebar in that courtroom. As soon as it, okay, we're getting word that actually court has resumed, so we're going to jump back into that courtroom. And Bob, stand by. I have a couple more questions I want to ask you about that defense. So, we're getting a word that they're going to a break. Okay, they're going for another break. So, Bob, I can ask you my question that I wanted to. The idea here of, what kind of evidence they'll put forward. You had mentioned the idea of him taking the stand. Do you think he's going to take the stand?
Well, I don't want a defendant, if I'm a defense attorney, to take a stand, because I go by the old maxim of the person who taught me trial law, that juries love to convict out of the mouth of the defendant on the witness stand. However, if I don't have another witness that can testify to the provocation, we don't know what this 12-year-old heard beforehand or saw beforehand. We just kind of know that what we heard from the prosecution's opening. Maybe you can get it out of the 12-year-old. Maybe you can get it out of another witness. But I don't think that I see that here in this case. In order for him to be able to successfully advance the defense, and this is what I did in the case that I'm talking about. I had a statement from the defendant. I purposely did not introduce the statement where he confessed to the killing because in the statement, he brought out passion provocation in the statement. So I didn't introduce the statement. I used other evidence to show that he was the murderer. Why did I do that? Because I knew he would be forced to take the witness stand and I would be able to cross-examine him because there was no other evidence to support his passion provocation defense other than him.
Yeah, and it's also a question of how would this guy even do on the stand? I personally haven't heard too much from him, and just based upon what his reaction is, I can't help but think of another case that we covered, the Adam Matos case. Heard the whole evidence and then went on and said that he defended himself against an entire family when really he brutally killed them, and no one believed his story, so it could backfire.
Yeah, I think I look at a number of trials that we covered, Jesse, like even the Van Dyke case, I use as my #1 illustration of the fact that I think that they had credible arguments they could have made, but for the fact that Van Dyke got on the stand and blew himself up. And so it is a very, very risky move.
Very risky move, but, we're going to have to see what happens. Now, there's so many sidebars happening today. We're going to have to take a break and see what happens after the next break. I do want to tease something, though, for you. At around 11 o'clock Eastern Standard Time, our very own Brian Ross is going to have an exclusive interview with President Obama's former border chief who was fired by President Trump. So that's going to be pretty interesting. We recommend that you check that out. Again, we believe we're going to be doing that at around 11 a.m. Eastern Standard Time. But before that, let's take a quick break. When we come back, we might be live in that New Jersey courtroom. Stay tuned. As the evidence is presented, you kind of get a feeling of the whole story of what happened. Bob, one of the most tragic aspects of this entire case is the couple's 12-year-old son who discovered Tara O'Shea Watson's body. And it's apparently that this young boy heard his mother say, "Just let me die in peace." And it was then that allegedly the defendant went to get those knives and finished her off. This is not the movies. This is not the movies. This is real life.
Yeah, Jesse, I've handled so many of these kinds of cases where actually the children were there when the murder took place. And if you put yourself in the place of this child, in one given moment, this child lost their mother and essentially their father. They've been kind of orphaned, if you will. And it's really sad and tragic to watch. And obviously it has lifelong impacts. I followed some of these young people that grew into adults, and some have gone into crime themselves and addiction, many of them. And then some of them have been extraordinarily resilient in the face of this suffering. One that I maintain contact with, weekly. And it's just a tragedy to watch a child lose everything.
Yeah, and there's like you said, there's different paths for everybody, but what we can clearly say is that it's just going to be a difficult life for the children. That's absolutely true. Let's continue on with this detective from earlier today.
What is that depicted on the screen at this time?
This is a view of the stove in the kitchen.
That was S-113?
I don't recall the number, sir.
Which is S-113?
Yes, S-113.
Okay. Next, move on to S-114. Again, what does that say?
This is a view of the stove pulled out, looking down at the ground behind the stove, and there's two silver knives with suspected blood behind the stove.
S-115?
This is a close-up of those same two knives with suspected blood.
S-116?
This is a view of the larger knife with the suspected blood stain, and you can see the damage to the knife as the blade portion of it is bent and in sort of a U shape.
S-117.
That's a view of the opposite side of the knife, the larger knife.
S-118?
This is the smaller knife with the suspected blood, and it had damage to the front tip portion of it, which was bent.
S119.
And that's the opposite side of the smaller knife.
Man, Bob, I still just can't get over the murder weapons that were shown today, the bent nature of the knives. I mean, that's staying with me. I think it's probably staying with the jurors.
Yeah, for sure. I mean, listen, as a prosecutor, you know, I'll give you a little practice point here, Jesse. He's doing a great job, this prosecutor, because he's not going too fast. He's letting those knives and those bloody clothes marinate in the jury's mind. I've seen some trial practitioners that go through the rote, blah, 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 did you mark this for identification? Did you bag it? Did you tag it? Can you identify it? And then stick it back in the bag. He's animating these things in front of the jury. She's squeezing every drop of emotional impact that he can in front of that jury. It's done very strategically.
Let's see what the defense would do, though, to try to combat this evidence. We saw their opening statement from last week. Let's see what they had to say.
Children. And sometimes you'll ask your kid who left the cereal out. And that child responds to you with a whole lot of things rather than the answer to the question that was presented to them. So is it a response, or is it just merely, or is it an answer? As each witness comes before you, ask yourself, who are they? What role do they play? Why are they testifying? And more importantly, not what they are saying to you, but what they aren't saying to you. When each person leaves the stand, are you left with concrete answers? Are you left with something that goes you closer to the answer of who killed Tara? Or are you left with more questions? Is your mind left wandering about, hey, that doesn't make sense. That doesn't add up. Yes, they told me this, but what about this? That's true. Listen intently to everything they're saying to you. Analyze everything that is being said to you. Determine whether it really makes sense to you. After the last state's witness testifies, and you were sitting there thinking and analyzing each of their testimony, you're going to be left with more questions than answers. All the pieces won't neatly fit in the puzzle and give you the picture that the government just painted for you. And you'll be left with one choice only, and that is to find Jeremiah Monell not guilty of the murder of Tara O'Shea. Thank you.
The idea here, the defense's opening statement, didn't really say that much, but they're trying to make a point. What is the point they're trying to make?
Well, contrary to what we're saying about passion provocation, they're coming right out and saying that he is not the person who committed this murder. Now, they can say that right now at this stage and wait to see what evidence develops. She said, when they get off the stand, are you left with more questions? I don't think so, Jesse. They're seeing some seriously brutal, non-questionable evidence right now. So you may see the defense do a course correction at the end of the case and say, if he did it, well, if you go passion provocation, you can't say if he did it, you say he did do it, and this is why he did it. But right now, she didn't give us much other than he's not the guy and he's not guilty.
Let me ask you this. So we didn't really learn that much from the defense's opening statement. You talked about it, that they may change their strategy moving on. Would it have been wise to reserve their opening statement until the conclusion of the prosecution's case, then put on their case?
I'm never a fan of that. I mean, each case is a little bit different, Jesse, but I think you always take an opportunity in your opening statement to at least position you and or your client in a way that the jury hears you, humanizes a little bit. It's a first impression, and I don't want the state to have the only say in the beginning of a case. We all know the axiom that opening statements are probably the most critical part of a trial because opinions start to be formed almost immediately. So I would never lose that opportunity as a defense attorney.
Bob, I know our time together is coming to an end this morning, so thanks for your input. Any final thoughts? We have about 20 seconds.
Jesse, it's been an inestimable pleasure to be the guest on the Jesse Weber Show.
Well, I want to be a guest on your show, so this is vice versa, okay? Fair enough?
You got it, Jesse.
All right, everybody. So here's what we're going to do. We're going to take a break. When we come back, our very own Brian Ross is going to have a special segment about President Trump's border wall, and he's interviewing two very special guests, former National Security Advisor Richard Clarke and former President Obama Border Patrol Chief Mark Morgan. It's going to be very interesting to follow. Now, it should be noted, if the Monell trial comes back, you can go to lawandcrime.com and follow it there. We'll take a quick break. We'll be back with Brian Ross. Stay tuned.